So, Michael, we'll go ahead and move on to you. Thank you all for this wonderful conversation. Again, for our families that are on, thank you again for all the wonderful questions. We do really appreciate it. Michael, thank you for being so patient.
No,
We're
no
so glad to
problem.
see your face.
I love to it's like a refresher course for myself every time I get to hear experts in this area. I always pick up new things and I love it. So I'm always happy to go at the end and I think kind of bring together everything that has been talked about today. So really quick, just an introduction of myself. My name is Michael Chiodini. I guess I've been working with the ARC now for probably 17 years. My son, Dylan Chiodini, is actually who thrust me into this part of financial planning. Dylan was blessed to us in 2005, but had a cardiac arrest shortly after birth from a heart defect. And so Dylan was full care needs. He had cerebral palsy, a brain disorder, a brain injury, as well as G-tube fed in a wheelchair. But he was such a loving young child and really helped mold me into helping other families kind of figure out, what do we do when it comes to planning for their future. And so I think for tonight, you guys have got a lot of great information around the legal work and the legal aspects and government benefits that are vitally important to the quality of life of our children. And I think now it's kind of like stepping back and saying, so, what are our first steps? What do we do to try to get kind of our families prepared for this? And I think today was a great start. So a couple steps. First thing I talk to parents a lot about, and it kind of a good leeway from the conversation about where you want your loved one to live and what you want their future to be like. And we refer to it as a letter of intent. And so it's a process that I think a family needs to take with kind of sitting back and learning a little bit about what it is for their loved one that they want in their future and what they want that to look like, where they want them to live, et cetera, friends and family and experiences. And then from there, kind of working through kind of that future financial cost of what that's going to look like. How do we marry the financial government support system that we have available to us along with the personal financial abilities that we can muster up enough assets or some assets to help fund that special needs trust. And then going further, creating an estate plan and like establishing a special needs trust we talked about today, funding that trust with either life insurance or other assets that you've accumulated, naming beneficiaries, and then reducing taxable stake. But we're just going to jump right into the letter of intent because I really think, of everything that you do today, probably the most important thing you can do is begin that letter of intent to help the other people in your life that are going to step into your role be a better care provider, a better trustee, and a better advocate for your loved one. And so in my life with Dylan, we created a day in his life. And so we went through kind of in a videotape of what our routines were. How do you bathe him? How do you get him up and out of the bed? How do you use his walker and his stander, his wheelchair? Believe it or not, it's not everybody knows how to use an accessible van. So we really created kind of like a video of a day in his life. We took him to horse therapy, which is something that he loved to do. We explained very, specifically the types of treatments for medical procedures that we would be open to in the future. People that we wanted involved in his life and people that we felt maybe were not there for the best of reasons. And really just kind of what we had in our hopes and dreams for him in the advent that, we died before him. I wanted to make sure that my sister-in-law was best prepared to provide for him in the way and the quality of life that we had. And it wasn't just about legal work and money and all those other things. It was really about just Dylan at first. But what I learned was having that structure of a letter of intent to give me myself and my wife kind of what we want for him really laid the groundwork of how we finance that. What do we need to leave to Dylan? We have two other children. We're both working spouses trying to muster up income and assets for our retirement. And now we're looking to possibly fund another generation's retirement. And so that's different than your typical financial planning. And for me, is really what brought me into doing special needs planning. So looking at a client and looking at the individual loved one that you're planning for, what is their income sources? Are they on SSI? Are they on SSDI? If you're not aware, those are two different benefit programs, and some clients and some children graduate off of SSI onto SSDI when their parents draw Social Security, or when they die, or when they become disabled. So rules change and income amounts change. Will they have income from work, whether it's working in a small job, self-employed? We have clients that work at facilities here that are specifically designed to help facilitate a work environment for them that they can thrive in, and it gives them purpose every day to go to work and do things, and it's very important to them. Other things like monthly living expenses, just we talked a little bit about food and housing and transportation, medical costs and recreation. I think of like Medicaid as being that source of medical costs, the big ticket items, but there's certain things that Medicaid's not going to cover, and additional costs that will be maybe with medical providers that don't don't accept Medicaid, for example. And then try to figure out where that shortfall is. And I kind of use the example, and you guys were using the example of housing. I always just had it in my goal to buy a home that's accessible for Dylan, that he could live in for the rest of his life. I felt I had enough family around us that would support that and would move in and be there. And we talked to them about that, and we were kind of all on board. But we also knew the financial cost that would have was extraordinarily much more than a living facility, such if you're familiar with Ponybird in Jefferson County, where people like my son who are non-ambulatory could live for the rest of their life. For us, we just wanted him to be here and do the things that we did as a family, and kind of experience those things in the church that we went to, and have a little disruption in the life. But we also realized that when I put pen to paper and began looking at the financial cost to fund that, it was substantial. And so each family's hopes, dreams, aspirations, and goals are different. And I think each letter of intent helps you kind of design the plan that you want best for your loved one. So really quick, we talked about this. I won't spend a lot of time on it, but what goes into a special needs trust? Really any asset that you can title, right? So CDs or cash, investments like stocks or bonds, real estate, life insurance. We see the most probably funding of special needs trust come from life insurance. I always talk about it because I think it's really important. It happens at the most opportune time when mom and dad aren't here. So if you haven't saved enough money, this completes the plan. And I think families need to realize that it's likely that they're going to need life insurance while they're in their planning stages for their loved one. It's tax-free, right? It's immediately available. And if done right, it stays outside the probate process, because we're going to have attorneys doing good estate planning to make sure that assets aren't going there. I always show this little slide because one of the things that we work with families is trying to come up with, what do we need to have here to fund the trust? And so we'll work with families with their income, with the expenses, with the lifestyle that they imagine for their loved one. And we try to back into what that number would look like if in case something happened early in mom and dad's life or in the caregiver's life. And so we want to try to find a single lump sum amount of money today that would be needed to fund that lifestyle for that child without running out of money. And so each family is a little different, but it's a process that we run them through. And in this scenario, we just use some very easy numbers of $3,000 a month minus $1,000 a month for SSI. It came up with a time period, which would bring their son 60 years from today. And so that provides some longevity for them and trying to figure out how much money is going to be needed for their loved one. And then lastly, I talk about it because it's probably, I've seen this conversation come up more in the last 5 years than in my whole career. But one of the concerns that we always have is that if mom and dad begin to need care for themselves and they're the primary caregiver for the child with a disability, if their assets begin to be eroded in caring for themselves, it may impact the ability to leave assets to the child. And so one thing that we talk a little bit about is, how do we address the concerns of long-term care? And those have changed over the last probably 10 years, and they really have come in 4 different ways. You have your traditional long-term care insurance, which is kind of like a homeowner's insurance premium. You just pay it, and if something happens, they pay out. If nothing happens, your money's gone. But since then, they've created other types of products, which include life insurance and long-term care and other strategies to help families address the concerns that they have with regards to their own care and where that might land with their child's needs and the need to fund that special needs trust. So kind of leading off the special need or the long-term care, I kind of have a little bit of a graph here that kind of explains the difference between funding it out of your own pocket and then moving towards traditional insurance products that help transfer the risk of something like that happening in order to protect the assets in the estate that mom and dad have probably earmarked to be there for their loved one. So I'm going to skip through a couple slides real quick. So a couple different things. I think, the biggest mistake is just to not plan. So, leaving today, I think starting your letter of intent and getting started with your estate plan, your legal work towards the special needs trust creation is an utmost importance to do. And I think also going through and looking at all of your assets and making sure, beneficiary arrangements are proper. If you've already done this planning, I always find that people that have gone through the work with the attorney and done the work, sometimes they forget to do the next step, which is actually transfer beneficiaries or ownerships into the trust. And so it's a really critical step that we want to make sure you're reviewing your assets and your investments to make sure that those are in proper place. I always tell this one, don't assume somebody's going to step up and do the job of a trustee or do a job as a care provider. Really important that you talk to them ahead of time, understand that they understand what your accomplishments or goals are for your child and for their future. And if it's something that they're really, able and willing to do, you'd rather know that now. You'd rather know that now than looking down from above and thinking you picked the wrong person. So really important thing. And also really being cautious about the trustees that you manage. There was a question that you picked. There was a question that came up earlier about trustees. And, I always tell you this, there's no trust police running around overlooking someone's shoulder, making sure they're doing the right thing. You can hire trust companies like the Midwest. You can hire bank trust companies as a co-trustee. You can bring in multiple people, whether it's, I always say 3 is better than 2, because if 2 people can't agree, nothing happens. But talk to your attorneys, talk to your counsel that you're working with about naming other individuals or bringing in other individuals in a capacity where they're kind of like I call them a trust protector, where they're really looking out for the needs of the beneficiary and just making sure that the trustee is doing the proper things with the monies inside the trust. And if, at the end of the year, I think that auditing is fair of the assets and what's been spent. And if there's money missing and, there's brand new jet ski sitting out in the front yard, we might have to question that. So really important that you pick good trustees, and the root of the word is trust. So it's someone that you really believe will be trustworthy to do the job. And it's an honorable job, but it is a difficult job. And there's a lot of tedious administrative work. And so talking with your professionals, I think, makes a lot of sense in making that decision for you. So I'll leave you with that. Beginning your letter of intent, start thinking about the people that you love to trust over the money and the individual. And start thinking about the people that will oversee the personal support caregiving duties and be kind of that other eyes and ears for you. Working with qualified special needs planning attorneys and trust companies is utmost importance. And working with folks, I think, like myself, but also with the ARC and the organizations that really understand the government benefits and the nuances to unlocking some of the opportunities there for families and for the loved ones that you have, and really getting the most out of the resources that are there. And so with that, Sandra, I'll leave it for questions or for any answers or questions that were there for us to answer that were still pending. And thank you.
So there is a little bit of difference in the administration of a first and a third party, but when it comes to vacations, and you boil it down, vacations are always covered.
Mhm.
So, and vacations, that includes food, transportation, hotel, all of the costs. So I'm sorry I wasn't clear in that, but vacations are always covered.
We have one says, can you name a special needs trust as the beneficiary in a joint survivor pension from a public school retirement? So I guess that would be like the PSRS or peers or something like that.
Not in Missouri. No, there's a few states out there. Um, the VA, I believe, the veterans benefits can be redirected, I think, to a first party special needs trust.
Yeah, you're hitting it right there. And
Yeah,
if you have, so Sandra, just real quick, if you have veterans that
Mhm.
come to your things, I'm happy to teach about how
Mhm.
that veterans benefit works. It's
Mhm.
very tricky, but yes, you could leave a veterans to a first party. I agree, Michael, with you. I don't think you can leave the teachers. How
So
that's
I
spoken. Yeah.
have a follow-up with that. So if it is, let's say you do have the teacher pension, and what if you rolled it over into something else? So like personally, I was a former teacher, and after I was done, I took my pension out and I rolled it over into my own Charles Schwab, thing. And what if that then was, so it was no longer in my PSRS, and then could I
yeah.
then leave it?
That would be the case where you elected the lump sum. And
Mm-hmm.
I've been doing it probably long enough to know that if you've got enough years in your retirement at the school system, the lump sum is nothing near what the
Mm-hmm.
pension is. And so it's a tough decision. I've seen parents have to decide that.
Mm-hmm.
It's actually where life insurance comes in handy, because if you're eligible and you can still get it, you can maybe take a little piece of that pension, use life insurance to recreate that asset. It's tax free. That's even better in that case.
What are the next step if the trustee isn't doing their job?
I'll punt to the attorney.
Yeah, I am too, because at Midwest Special Needs Trust, we serve as trustee, and we can remove a co-trustee if we decide to. So ours are a little bit different, but if you choose your own trustee, that's a good question. Yeah.
Mm-hmm.
Yeah. So when you say not doing their job, I mean, it can mean, various things, but if they're doing something egregious, like, breaching their fiduciary duty, the guardian or somebody on behalf of the beneficiary of that trust could remove them, could do various things to take them out of that role. You could also build in the flexibility in some of these trusts. Mike kind of mentioned a trust protector, but that is like an actual role where it's an individual who's not who doesn't take any action until called upon, but one of their actions is to remove and replace the current trustee. And so, I mean, there's a ton of ways that you can remove them if they're not doing their job, but part of it arises to like, what level of not doing their job are they at? But there are ways to remove and replace them.
Is that through court, or is it just filing a document?
So yeah, so like in a lot of the third party trusts that we do, we do put the role of trust protector in, and basically they would do sort of like an amendment to this irrevocable trust that allows them to remove and replace the trustee, change some things for like tax purposes. It's more of like an administrative role, so you don't have to go to court for it. If the trust doesn't provide ways to remove and replace the trustee, you would end up in court through some type of judicial modification.
And do you guys use trust like advisory boards or anything where if a group of friends and families are the ones that are kind of overseeing to get, so we have the trustee and then you have a group that makes some of the administration decisions so that there's a consensus? You said 2 is better or 2 is worse than 3, right? Because 2 is nothing getting done. So I know that other trust organizations use like advisory boards. I didn't know if that's something that you all do.
It's not something we have done it. We don't do it in all of them. At some point, it's that whole too many cooks in the kitchen situation,
right?
To where,
Yeah.
I mean, if you're truly trying to get something done efficiently and effectively, it's a lot of people, right? But that's not to say we haven't done it and we don't do it. It's just not something we typically do.
I know there are like major advocates for advisory boards. And I do think they serve a purpose in some
Mhm.
places and for some people, but may not be good for everybody. Yeah.
Yeah.
I just wondered.
Okay, a couple more things about the trustee. Does the trustee removal involve a judge? And also, does the trustee get paid? Someone said it sounds like an intense job.
So with the removal, depending on how it's done, if you're going to court for a judicial modification, it does involve a judge. But there are ways to do it without court involvement. It just depends on circumstances and everything else, but it can. And then does the trustee get paid? So the trustee is a compensated role. And then, I mean, Casey can tell you about her company, but in all the trusts that we prepare, if it's an individual trustee, the trust allows for reasonable compensation. If it is a corporate trustee, such as a bank, a trust company, well, they are certainly going to be paid, and it's typically based off a percentage of the trust assets. Like a lot of trust companies have a published fee schedule that you can find online. If you can't find it, you can call them and ask. I mean, it's all public information. They're not going to hide it from you, especially if they want you to name them and hire them. But it just depends, trust company by trust company.
And what I'll say is I did so yes, our fees are published. You can visit our website. You're going to find they're significantly lower than any bank or corporate trustee out there. But they are in line with other pooled trust organizations. When I was doing a fee analysis, because we are allowed to change our fees, and I was doing a fee analysis trying to find published fees for special needs trust administration is trying to find a needle in a haystack. They're not going to be they're going to give you their base fee, and then there are additional fees that are on a schedule somewhere else that they're not going to disclose over the phone. So I was advised to maybe add 3 or 4 percentage points to what they're charging as a base fee for special needs trust administration due to the complexity of it. So there are some very, very good corporate special needs trust trustees out there, but they are on the more expensive side of that.
And the only thing I'll add to that is you'll also find that like Commerce Bank, for example, like they are moving away from administering special needs trust because of the complexity, because of the potential liability of
the litigation
losing public benefits. And so it's harder and harder to find, and when you do find them, as Casey said, it tends to be more expensive.
And not to toot our own horn here, but it's why we can be an option. So if we're not a great option up front and you want to use a corporate trustee, that's great. I love that. But then when the corporate trustee is ready to resign or below the asset limit or the family is done, right? Then you can build into your trust documents, into your special needs planning. Then I want it to go to Midwest Special Needs Trust or to a pooled trust when it reaches a certain point. And we actually see some fruits of that labor recently where we've had more banks call us and say it's at the end, it's nearing our end, and they want it to go to you. And so, no, we weren't the first option, and that's fine with me. But we're an additional option so that benefits aren't impacted. And yeah, I've talked to a lot of bank trustees who are like, we want nothing to do with it. It's complex, it's difficult, it's a different population than they're used to, all of the things that go with it.
Most of the corporate trustees are $1 million minimums. I mean,
and you may find the local bank to be 500, but it's starting at $1 million for a big bank.
The spend rate can be so high, right? I mean, so you're dipping into principal, and I mean, there's a lot of needs.
So somebody asked, what is an acceptable percentage to pay the trustee? Anybody would like to throw their hat into that?
I'll tell you, our fee is 1.5% per year, essentially.
Yeah, I'd say 1.5 to 3 is probably right. I mean, but it just depends. And if it's an individual trustee, I mean, then we're, then you're probably not talking percentage, you're probably talking,
Flat rate.
Yeah, we say, yeah, so.
This is directed for Casey. So does every state have an organization like yours then as an option to go through an attorney and finding your own trustee?
So kind of. So there are pool trusts, there are national pool trusts, there are regional pool trusts, and there are state pool trusts. We and one other pool trust organization are the only ones established by state statute. So not every state has one just like us. Most of them came out of the ARCs, actually. Many of the ARC of Texas is a huge pool trust. So, but yes, unless you live in, I think it's like Idaho and Louisiana don't have state-based pooled trusts, but you could go to a national one and utilize the services there. So yeah. And we
Yeah.
serve Missouri and all of the surrounding states. So that helps kind of this group that may be looking for state line boundaries.
And there's one more, in terms of medical needs, who is typically determining when it is necessary or scheduling periodic visits, annual visits, 6-month recurring appointments, things like that?
So that's less to do with a trust
Yeah.
and much more to do
guardian
with
or-
a guardian.
Yeah,
And
the
so-
guardian.
Yeah, so once the kid
Okay.
turns 18,
Mhm.
mom and dad, they're still mom and dad, but their legal rights over their child, Joey, are much, much different.
Mhm.
And so you would apply for guardianship at that point so you can maintain those legal rights.
And
Yeah.
I will chime in, and I will just recommend, we do have on our YouTube page as well as, you all have been, your previous, Q&As are on our YouTube page. This will be on our YouTube page, but we also have, some videos about guardianship and also what's called supported decision making. Maybe guardianship isn't what you're ready for or your loved one isn't ready for. The ARC is really big on person-centered choice and your loved one being able to make as many choices for themselves as they are able to, and take as many risks, have risk mitigation in place, of course, but there's we just did some videos on that, and there's so much more we could go into about that. But you can reach out to me, and I can get you in touch with some of our wonderful family support staff, and we can talk to you so much more about why guardianship, yes, might be the right way to go, and why there could be other options for your loved one and your family as well. So
Little tidbit. Sorry.
Yeah,
Little
please.
tidbit about me is before I started with Midwest Special Needs Trust, I worked for the public administrator's office for 5 years. So guardianship is close to my heart, but I've seen the changes in the last 20 years of what it was when I started and what supported decision making has become now. And it's a beautiful change over 2 decades. So just a small little, I've seen the change, because 20 years ago we'd have this conversation and we'd say it was guardianship, and now it's a completely different conversation where guardianship is only an option and not the first. So
right, for sure. And we know,
sorry about that.
No, the state of Missouri it's one of the highest states for guardianship. It's like 80%. And really that's really, really, really high compared to the rest of the nation. And just a lot of families just don't know about that there's another decision out there, another choice out there. And so we want to, but we want everyone to do what's best for their family and their loved one. And that's really what we encourage for you to do for your family.
Absolutely.
What's best for you and your loved one. So.
I was just going to add something, if you don't mind.
Please.
It's kind of in the government benefit side where I've seen some problems, and I'll just so Missouri added something called self-directed services. And one of the rules is that if you're the guardian, you cannot be a paid caregiver. So if both mom and dad become dual guardians, which I totally get the reasoning behind that, when this opportunity, and this happens to my clients where they can't find anybody to care for their child, mom's got to quit her job to stay at home, but mom and dad are the guardian, the kid's 22, and the self-directed services is great, but they can't find anybody. So not that I caution people on guardianship, I just say you really got to understand the government benefits side of things, what you're giving up, what you're getting, and really think about it. Because if I would do it over again for a lot of my clients, I'd say one of you get the guardianship, the other one's going to be the paid caregiver. Especially now where if you're a paid caregiver for a loved one that lives in your home, it's federally income tax-free money. I mean, that's a big deal. So I'm always about extrapolating the most out of the services that are there within the law. And so if that's something where a client, that might be in the future, before they go to guardianship, they really need to think about, do one of us do this? And yeah, I get it. You're going to have to probably go back to court if something happens and one of you, the guardian dies. But I caution and I just encourage people to really look at all those resources. As I think it was the Family to Family Resource Center that has the guardianship decision-making thing. And I always love
mentioned Missouri Family to Family. Yeah.
Anyway, so I just thought I'd share that with you because it's been a thing, and it really started popping up after COVID where parents couldn't find anybody. And then they were like, oh, well, I'm going to do this self-directed. And they're like, oh, no, sorry, you're the guardian. And they're like, oh, so something to think about, and really encourage, what you said as well is just learn it before you just jump into it.
We did have one last question pop up. Sorry. Are there any conflicts with being both the guardian and the trustee? No, everyone's shaking their head.
What I will say to that, so when I think of guardian, I think of guardian of the person, and then Missouri designates the conservator, which is conservator of the estate. And then you have the trust. Those are three separate entities, and the conservatorship assets are not what's in the special needs trust. And I work with a lot of conservators that say that have a hard time designating the difference, right? Because they're in charge of everything. And then there's a special needs trust that they may or may not have control over. But because it's an exempt asset, it is not considered a part of the conservatorship. And so keeping that in mind, yes, they can be the same person, but they're three different hats. And it's important to know. So sometimes it may be better to have one person, and then sometimes it may be better to have three people or two people, a guardian and conservator and a trustee. So that's my 2 cents in it.
Yeah, I absolutely. The other thing, I mean, like, I'd say more often than not, clients will name the trustee and the guardian, like a guardian, as the same person. If you do it if you separate it, all I would say is you do create a little bit of like a checks and balances approach, right? We have one person caring for the person, another individual caring for the money. So they have to work together to make sure no one's misusing it. Great from again, checks and balances, but from a convenience standpoint, it may slow things down, but that might not be the worst thing. But no, you can absolutely do it. And I'd say the vast majority go that way.
100% agree with that. Yeah.
Thank you so very much. And thank you all for joining us. And we hope everyone has a wonderful, wonderful night. Thank you so much.
Thank you.
Thank you.
Bye-bye.